Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're continuing with our ongoing series entitled The New Era Face-to-Face Evaluation, and this is session 5 in this new series. Now today, I want to share with you a major development that's occurred for qualified medical evaluators in the state of California. And I want to share with you how that new development impacts your face-to-face evaluation. Now, in the first 4 sessions of this new program, we spent time talking about how the Division of Workers' Compensation's new interpretation of the complexity factors under CCR 9795 has mandated changes in the way qualified medical evaluators go about the process of evaluating injured workers. And because of the DWC's new interpretation of the complexity factors, we were seeing more and more reports being driven down into the ML 102 and ML 103 levels of reports. Well, it seems that there's a new ray of hope, and there's been a major development wherein the Division of Workers' Compensation has now lifted their oppressive interpretation of the complexity factors, and we're going to see more reports now being duly reimbursed at the ML 104 level as they formerly were and as they formerly used to be. But that does not change the relevance of the discussions that we've had up till this point in time. Still, we're going to be seeing reports that truly qualify as ML 102 and truly qualify as ML 103 reports, for which all of the philosophy of our preceding 4 sessions still apply. And it's the Division of Workers' Compensation's position that even though some of the oppression regarding the complexity factors has now lifted, the Division of Workers' Compensation is still concerned that doctors properly classify their reports according to the exact definitions of ML 102, of ML 103, and ML 104. And the whole purpose of the Division of Workers' Compensation's discipline and denial of QME reappointments is to contest and protest QME's improper use of the complexity factors and improper billing of their reports through misuse of not only the complexity factors, but also of the modifiers under CCR 9795. So all of what we've talked about up till now regarding establishing the complexity of your evaluation, setting up your evaluation in advance, knowing exactly all the issues that you'll be required to resolve in your evaluation, knowing all of those issues in advance, and being targeted, directed, and focused in your evaluation, all of that still applies. Similarly, all of what we've talked about in terms of assessing examinee credibility and terminating the evaluation in those instances wherein you determine that the examinee is not credible, all of that still applies. And we're going to talk about how the face-to-face evaluation has still changed or still needs to change, even though the DWC has now reversed their oppressive interpretation of the complexity factors. There's still going to be requirements that we change and improve our face-to-face evaluation, and so I will address those changes in our very next session. In today's session, I want to share with you the new QME settlement agreement that has been reached by a Los Angeles law firm and the Division of Workers' Compensation in the lawsuit that's been filed, or that was filed, by qualified medical evaluators who had their reappointment applications denied by the Division of Workers' Compensation due to the Division of Workers' Compensation's concerns for improper billing and improper use of the complexity factors under CCR 9795. Well, this is good news for all of us qualified medical evaluators that this oppressive interpretation has been lifted, but it begs the question, and it asks us all to look inward at our procedures and it asks us to take a look at where do we go from here? Where do we go from here now that we've narrowly escaped and dodged bullets from the Division of Workers' Compensation? You know, it's no exaggeration to state that the system as we knew it basically had dissolved and disappeared for the period of time up until just recently when the new QME settlement agreement was reached. The system, we had lost the system. We had lost the profitable evaluation reports under ML 104, being left simply with cost ineffective reports under ML 102 and ML 103. So it's no exaggeration to state that the system as we knew it had dissolved, at least for the time being until this matter was resolved. Well, with the new QME settlement agreement, it seems that the ML 104 report has been reestablished. And so qualified medical evaluators are now given a breath of fresh air, a breath of new air. It seems that we're being given a second chance by the Division of Workers' Compensation to do it right, to do our reports correctly, to actually comply with the QME regulations and produce reports that are ethical and that comply with all the rules and regulations that govern the QME process. So here we are given a breath of new air, and it begs the question, where do we go from here? Will qualified medical evaluators look at this as a second opportunity, a second chance to have their profession back, to have their profession given back to them, so to speak? Or will the fraudulent and overbilling qualified medical evaluators look at this as yet another opportunity to continue doing business as usual? Well, this whole situation and whole scenario sort of reminds me of a story I once heard about the mule that wouldn't plow. Have you ever heard the story of the mule that wouldn't plow? Well, it seems that one day a farmer was at the farmer's market or the flea market, and he came upon a mule for sale. And there was a sign by the mule that said, "Best plowing mule in the county." That's what it said on the sign. Best plowing mule in the county. Well, the farmer purchased the mule, took the mule back to his farm, took the mule out in the field, hooked the mule up to the plow, and the mule would not plow. So the farmer encouraged the mule. The farmer cajoled the mule. The farmer tried to entice the mule with food. The farmer tried to push the mule. The farmer tried to pull the mule. The mule would not plow. So the farmer did what any one of you or I would do. He called up the former owner of the mule and said, "Hey, I thought you said this was the best plowing mule in the county. This mule will not plow." Well, the original owner of the mule said, "I'll be right over." The original owner showed up, went out to the field, and took a big piece of fence post, about this wide and this long. And he took the piece of fence post in his hand, he went over to the mule, and he raised the mule's tail, and he whacked the mule across the mule's testicles. Whereupon the mule commenced plowing. The original owner of the mule turned to the farmer who had just purchased the mule and gave him the lesson, and the lesson was that first, you need to get the mule's attention. And this swath across the testicles served to wake the mule up and to get the mule's attention so that the mule could then become receptive to commands. Well, it seems that the Division of Workers' Compensation first had to get our attention, had to first give us a swath across the testicles, metaphorically speaking, to wake us up as qualified medical evaluators, to get our attention to fraudulent activity taking place within the qualified medical evaluation sector of the workers' compensation system. It seems that fraud is rampant in all aspects of the workers' compensation system, and the qualified medical evaluation is no exception to fraudulent activity. And so we will never know why the Division of Workers' Compensation elected to enact the new interpretation of the complexity factors. We'll never know. It's never been written. It's never been admitted. But it's my opinion, based upon the reports that I've reviewed, it's my opinion that this is the Division of Workers' Compensation's attempt to get our attention and to wake us up and to combat and to contest fraudulent qualified medical evaluations wherein doctors are way overbilling for the reports and are for billing for activities that they did not actually perform in the qualified medical evaluation. This was simply the Division of Workers' Compensation's attempt to combat fraud within the qualified medical evaluation. Well, they certainly got my attention. I hope they got your attention as well. And I'm asking you to join me and for all of us to join together to take this new opportunity to improve what it is that we do, to improve our evaluations, to improve our reports, to improve our reporting so that our reports more closely comply with all the requirements that are described in labor codes and codes of regulation. I'm asking us to take this opportunity to receive the gift that's been given back to us by the Division of Workers' Compensation and see it for what it actually is, and to hold it gingerly and to caress it lovingly and to do our qualified medical evaluations according to the exact letter of the law. Now, what I want to do with you, what I want to share with you in today's discussion is I want to go over the QME settlement agreement with you so that you understand the language within that settlement agreement and how that language affects you. And then I want to share with you a couple of examples of medical legal reports that inflamed and incensed the Division of Workers' Compensation when they discovered these QME reports. And these reports contributed to the whole debacle that has now just been resolved. So I've included for you in today's materials a copy of the QME settlement agreement. So I'd like to have you to go ahead and retrieve that agreement, and I'll retrieve mine as well so that we can go over that together. And I look forward to being back with you here in just a few minutes as we continue our ongoing discussion involving the new era face-to-face evaluation. And today we're talking about the new opportunity following the QME settlement agreement. So we'll be back with you here in just a very few moments. Okay, I'm back with you now, and I have my settlement agreement here. I hope you have yours as well, so that you can lay your own eyes on some of the language that I want to try to decipher for you here in today's discussion. So this is the settlement agreement. It says settlement agreement and mutual release of claims. Now all the names in this settlement agreement have been redacted, but we know that this was the Dr. Howard and other doctors versus the California Department of Industrial Relations. And this is signed on April 4th, 2018. So this was signed just a couple weeks ago, and it was recently distributed. It wasn't distributed on the 4th of April. It was just recently distributed a couple of days ago. So there was a couple of week delay while this got, I guess, processed internally before it was released to the public. So this is brand new. This is new information to all of us. and we're all sort of trying to digest and decipher what this actually means. But I'm here to tell you that this represents good news. Good news. So the first two pages of this settlement agreement relate specifically to the doctor involved, and the doctor's name has been redacted. So I don't know if this relates to Dr. Howard or any of the other doctors that were involved in the initial filing of this lawsuit, which was Drs. Howard, Dr. Simon, and Dr. Johnny. But anyway, so the first two pages go over some agreements specific to the doctor. But then we get into Section 10, and Section 10 I have highlighted here, and this talks about the additional agreements regarding QME appointments, and these are referred to collectively as the additional agreements. So the remainder of this document refers to additional agreements. So let me share with you some of the good news from the additional agreements. In section number C, this is 10C, page 4 of this document, talks about the agreement that's been reached regarding the causation complexity factor under ML 103 and ML 104. And you'll recall that the Division of Workers' Compensation was contesting the use of medical causation as a complexity factor and was allowing the use of causation as a complexity factor only in cases that involved denied claims. Causation as a complexity factor, according to the DWC, could not apply in those cases that involved an accepted claim because causation, meaning AOE, COE, was no longer an issue in the case of an accepted claim. Well, that was an interpretation of the complexity factor based upon, I should say, not based upon the exact written letter of the language of the causation complexity factor. So the agreement that's been reached is that the causation complexity factor shall apply exactly as written in the language of the law under CCR 9795. And this is good news. This reestablishes causation as a complexity factor. So let me read this to you. It says that when trying to assess whether the qualified medical evaluating physician has complied with the medical legal fee schedule with regards to the causation complexity factor, it simply says in the language of the law, quote, addressing the issue of medical causation upon written request of the party or parties requesting the report, unquote, shall be applied as written, as it always was. When you receive a written request from the party or parties requesting the report, requesting you to address causation, then causation as a complexity factor now again applies. Without any additional requirements, without any additional interpretations, or without any other additional conditions imposed by the Division of Workers' Compensation. In applying this regulation as it's written, the DWC agreed not to impose any additional requirement that the underlying injury claim have been denied or contested by the insurer. They agree not to require that both parties, as opposed to a single party, have requested that the issue of causation be addressed, and they agree not to require that any written request that causation be addressed include any specific words or any specific phrases. So, as we've always enjoyed causation as a complexity factor, it is now restored. As long as you receive a written request from the party, singular, or parties, plural, to address causation, you can employ causation as a complexity factor, and this is fabulous news. This is a fantastic settlement that's been arranged by the Los Angeles lawyers defending the doctors in this case. Section D, so that's great news. Section D involves more great news, and this has to do with the time billed under ML 104 for report preparation. You'll remember that under the DWC's new interpretation of the ML 104, the time involved with preparing the report, which could be hours and hours and hours, by most estimates, the time involved with report preparation is at least 50% of the entire time involved with the evaluation in total. So if the entire evaluation involved 14 hours, at least 7 of those hours are involved in directly writing and preparing the report. So under the new interpretation of this complexity factor, the Division of Workers' Compensation was requiring that we write off more than 50% of the total time dedicated and devoted to the preparation of the report, causing us more than a 50% reduction in our reimbursement on these reports. Well, the time involved with report preparation has now been restored, if you can believe that. And this is a fabulous accomplishment by the lawyers in Los Angeles. It says that the section under ML 104, Section 3, states, under Pathway 3 to the ML 104, it states that when billing under this code for extraordinary circumstances, the physician shall include in his or her report, number 1, a clear, concise explanation of the extraordinary circumstance related to the medical condition being evaluated, which justifies the use of this procedure code, and number 2, verification under penalty of perjury of the total time spent by the physician in each of these activities. Number 1, reviewing the records. 2, face-to-face time with the injured worker. 3, preparing the report. And if applicable, any other activities. This language, under the new settlement agreement, shall be applied as written. Respondents agree, meaning the Division of Workers' Compensation agrees, that as written, the word code, meaning where it says when billing under this code, the ML 104 code, when billing under this code, in this provision, it applies to all subsections of ML 104, including subsection 1, subsection 2, and subsection 3. Prior, under the Division of Workers' Compensation's new interpretation of the complexity factor, the time involved with report preparation was only paid in those cases where the qualified medical evaluator was able to obtain a prior written agreement from the party or parties that the evaluation involved extraordinary circumstances. Well, there's 2 other pathways under the ML 104 that qualify the evaluation as ML 104. One of the pathways is 4 or more complexity factors. A second pathway is prior multiple injuries to same body parts involved with the current evaluation. And under those 2 pathways, the Division of Workers' Compensation was prohibiting that the time involved with the report preparation be reimbursed. Only under the 3rd pathway to ML 104, which involved a prior written agreement, could the qualified medical evaluator expect to be reimbursed for his time involved with report preparation. This was a preposterous interpretation of the ML 104, but the Division of Workers' Compensation exploited it to restrict and tighten the circumstances under which we could be reimbursed for report preparation. I don't know if you remember the exact language of the ML 104, which I have right here. Here's the ML 104 under CCR 9795, and it describes Pathway 1, Pathway 2, and Pathway 3 to the ML 104. And it seems that where the highlighting begins, there used to be a space between these sentences and these sentences, where these lower sentences that state when billing under this code for extraordinary circumstances, this paragraph in highlight used to apply to all three pathways. But the Division of Workers' Compensation's new interpretation was that because this was all part of the same paragraph and there was no spacing between these sentences, that this requirement that report preparation be reimbursed applied only to pathway 3 and not to pathways 1 and pathways 2. Which was preposterous, but they did it, and it hurt terribly. It hurt terribly because it was so difficult to get a prior written agreement from the parties. The parties had no incentive to do that for qualified medical evaluators, and very few instances wherein qualified medical evaluators requested a prior written agreement did the parties actually agree and comply and provide the doctor with a prior written agreement. So to have the report preparation time reapplied to pathways 1, 2, and 3 is an unbelievable breakthrough for qualified medical evaluators. This basically restores the ML 104 that we had temporarily lost. This restores the qualified medical evaluators' hourly rate, which the Division of Workers' Compensation was requiring that we write off the entire time involved with report preparation, basically demanding that we write the report for free. Well, we're now having our reimbursement for report preparation time restored. Okay? So that's a fabulous outcome. And then finally, a couple more things. Another term of the settlement agreement has to do with medical research. Now, this is important because I've found many doctors misuse the medical research complexity factor in a variety of ways, and I'm going to share with you an example today of how one doctor misused medical research. But it states basically the Division of Workers' Compensation was clamping down on what they considered to qualify as medical research. And one of the contentions that they had was that medical research did not include you as the doctor researching topics within your scope of specialty. So, for example, I'm a chiropractor, and if I had to do some medical research on the spine, maybe regarding some condition of the spine or some new treatment being applied to the spine or some new findings relating to the examinee, for example, within the anatomic region of the spine, that was considered to be within my specialty as a chiropractor. And research within your own specialty was being disqualified by the Division of Workers' Compensation as medical research. Well, there's nothing in the language of the law or in the description of medical research under CCR 9793 and CCR 9795 that specifically prohibits medical research within your own area of expertise. So it states under medical research that in applying these regulations as written, the Division of Workers' Compensation agrees not to impose any additional rule that a qualified medical evaluator may not bill for medical research within his or her own area of specialty. So this reopens the door to medical research even with your own area, within your own area of specialty, if there's some issue related to the medical condition involved that requires that you learn about or bone up on or review. It's now been reestablished under this settlement agreement. And I'll have a few more words to say about medical research when we get to our example in just a few minutes. And then finally, and this is unbelievable, this has such broad ramifications, it's going to blow you away. It says under settlement agreement term number 11 here in highlight. You may or may not be aware, but the Division of Workers' Compensation published an educational video on 11/15/2017. Now this video is being produced in April 2018. So approximately 5 to 6 months ago, the Division of Workers' Compensation published this educational video wherein they described their new interpretation of the complexity factors and their new requirement as to how we bill our QME reports. Well, it seems that insurance carriers and also independent bill review adopted the Division of Workers' Compensation's educational video in paying QME reports. In the case of insurance carriers, they adopted the Division of Workers' Compensation's requirements for billing in reimbursing our QME reports. And then number two, independent bill review adopted the Division of Workers' Compensation's educational video in their review of contested billing issues for qualified medical evaluations. So the tenets and the principles contained within the DWC's educational video prevailed, and doctors were starting to see that despite what they were billing for their reports, the insurance company themselves were putting the report through a series of filters to make sure that the report either complied or did not comply with the Division of Workers' Compensation's educational video. And in those cases where they found that the report did not comply, they took it upon themselves to reduce the reimbursement of the report consistent with the principles of the DWC's educational video. And if you had a problem with that, if you had a disagreement with that, you could then send your billing to independent bill review for their review of the situation. And guess what? Independent bill review, of course, adopted the educational video for purposes of evaluating QME's billings for the reports. So now, under the terms of the settlement agreement, it states that the Division of Workers' Compensation agrees to modify the content of the online QME training module that is currently posted on the DWC website so as to make the content of and statements and material within the training module as interpreted in a reasonable and common sense manner consistent with the additional agreements here, and such modifications shall be made within 60 days of the effective date of this agreement. So this is fabulous. This is fabulous news. No longer can insurance companies take it upon themselves to reduce QME reimbursements based upon the Division of Workers' Compensation's interpretation of the complexity factors, and no longer can independent bill review do the same. So with this one agreement, it seems that the ML104 report and the reimbursements required, the reimbursement that the qualified medical evaluator is expecting to receive is what the qualified medical evaluator will receive and cannot be reduced by the insurance company, and in the case of a dispute must be upheld by independent bill review. So this is fabulous news. And with this settlement agreement, qualified medical evaluators are getting a new second chance with all the reimbursements restored, all the complexity factors restored, with all of our former reimbursement rates at $250 per hour for all activities under the ML104 restored. So the question becomes, where do we go from here? How will we use this new opportunity? Will we use this new opportunity in the spirit that is given to us, or will we abuse this opportunity and look at it as a new opportunity to fraudulate and overbill for activities in our qualified medical evaluation reports that we don't actually do? Well, I'll have more to say on that in just a few moments. And before we get into that, I want to share with you a couple of reports that I've had the opportunity to review. And these reports represent the types of objections that the Division of Workers' Compensation has had to qualified medical evaluators reports and suspicious for fraudulent billing within those qualified medical evaluation reports. Now, these reports relate to no doctors specifically. They don't specifically relate to the doctors in any way who have been denied reappointment with the Division of Workers' Compensation. I simply present these reports to you as examples that I've accumulated over the years as examples of cases wherein qualified medical evaluators either did not understand the complexity factors and the use of the complexity factors, or the doctors intentionally misused the complexity factors in order to fraudulently escalate and elevate the cost of their reports. So, time permitting, I want to share with you 3 reports here. So, let's begin. The first report I want to share with you is right here. Now, what we have here is qualified medical evaluation report for a neuromusculoskeletal type injury, and it seems that this evaluation involves a reevaluation. So this examinee has been already evaluated one time by this particular qualified medical evaluator, and in this case this involves an agreed medical evaluator. So it contains a cover letter here from the insurance carrier, and the cover letter asks the evaluator that he's being asked to address the level of permanent disability and also to discuss any need for future medical care. Those are the issues: the level of permanent disability and as well as a future medical care allowance. Very limited report, it would seem. There's no questions here regarding causation, because this has been an accepted claim. There's no request for any discussion of causation at all. The report does discuss apportionment, or the cover letter does request an addressment of apportionment in the case of permanent disability, and basically that's it. So it would seem that this would be a relatively uncomplicated or non-complex evaluation, but the doctor apparently doesn't see it that way. The doctor creates a very interesting report. The report does not comply with any requirements under CCR 34, does not comply with any requirements under CCR 35.5, under CCR 40. For example, in this report, in the opening paragraphs, it contains no admission as to the location of the evaluation. It contains no reference to any compliance with the disclosure requirements under CCR 40. So let me just read for you just a couple of these requirements so that you can see how this report is lacking in substance and in format. So I'm not sure if you're aware, but there are many labor codes and codes of regulation that govern the QME, the content of the QME report. One of those are CCR 34 and 35.5B, which have to do with the location of the examination appointment. The Division of Workers' Compensation is quite concerned that we not change the location of the examination appointment, at least on the initial evaluation. And this is described under CCR 34B. It says the QME shall schedule an appointment for a comprehensive medical legal evaluation, which shall be conducted only at the medical office listed on the panel selection form. That's CCR 34. Well, CCR 35.5 follows up on that, and it states, each reporting evaluator shall state in the body of the comprehensive medical legal report the date the examination was completed and the street address at which the examination was performed. Nowhere in this QME report does the doctor describe the location of the evaluation. So What that tells me is that this template that the doctor is using is not a template that's customized to California workers' compensation. Rather, this template is something that's extracted from his private neuromusculoskeletal orthopedic type of practice. It's not customized to California workers' compensation. California workers' compensation requires a specific template that complies with all the rules and requirements. Further, CCR 40, which are the disclosure requirements, tells us that an evaluator selected from a QME panel shall advise an injured worker prior to or at the time of the actual evaluation of the following. And it lists here on CCR 40 several things that were required to disclose to the examinee prior to or at the time of the evaluation. So what should you do in your report? How should you demonstrate to the parties that you complied with disclosing to the injured worker prior to or at the time of the evaluation? You should put a statement in your report that you complied with this requirement, and nowhere in this report is there any such statement. So this is a report that the doctor has no idea what he's doing in California workers' compensation, and yet he expects to be paid premium dollars for his supposed ML-104 report. So in describing his report, he says 4 hours were needed in review of records, which we'll talk about. 2 hours were spent with the patient, so that's 6 hours. That could qualify as an ML-104. And 2 hours in preparation of the report. Issues of apportionment were discussed. This report will be billed as an ML-104 report. So let me ask you, does discussing apportionment qualify as a complexity factor? It does not, does it? Discussing apportionment as a complexity factor only complies as a complexity factor when certain criteria are met. And the criteria are quite steep. It requires 3 or more injuries to 3 or more body systems or 3 or more employers, and all these criteria, which are a very tall threshold for the apportionment complexity factor. Well, he states that issues of apportionment were discussed, so let's see if his discussion of apportionment qualifies as a complexity factor. So we have 4 hours for review of records, 2 hours face-to-face, that's 6, and 2 hours in preparation of the report. So that's 8 hours, 8 hours. Now, if this was a bona fide ML-104, and he had a bona fide issue of apportionment, or he had a bona fide issue of causation, or he had some of the other complexity factors, how much would 8 hours be billed at? At $250 per hour, 8 hours would be billed at $2,000, correct? Okay. Well, here's the doctor's billing statement, wherein he describes billing for an ML-104 at $4,400. He takes a $2,000 supposed ML-104, and we're going to reveal that the ML-104 does not even actually qualify as an ML-104. It more closely qualifies as an ML-103. So he invokes apportionment as a complexity factor in order to artificially elevate and escalate the report to the ML-104 level, which, if it actually qualified as an ML-104, based on the 8 hours of time involved with the evaluation, would bill out at no more than $2,000. Well, the doctor, for whatever reason, multiplies his hours by 2.2 to come up with a billing level of $4,400. And this is the type of thing, this is the type of situation that the Division of Workers' Compensation gets inflamed about. Can you understand that? Well, let's review the report. It's my opinion that this report qualifies as no more than an ML-104. First of all, the doctor does not describe his face-to-face time. He says that 2 hours were spent, but the doctor gives no face-to-face start time, no face-to-face stop time. He talks about review of records being 4 hours being involved with review of records. And if you look at the review of records section of the report, the review of records section of the report, which begins, by the way, the report itself is an 8-page report. The doctor bills $4,400 for an 8-page report, and then he includes the review of records as an additional addendum. It's not incorporated within the body of the comprehensive medical legal report. The review of records is attached as an addendum. And if you review the review of records, you'll see that the doctor simply takes each of the medical records that he reviews or that he received and recapitulates the entirety of the record here within this addendum. So every single word that's on every single record that he received is found in this review of records. Now, that's not how the law requires that the review of records be completed. The law, and there's 4 laws, there's 2 labor codes and 2 codes of regulation that govern the review of records procedure, and the doctor does not comply with those. The review of records is supposed to reflect the qualified medical evaluator's extraction from the medical records relevant, salient data upon which the opinions and conclusions in the report can be based, or will be based, or are based. This doctor's review of records simply involves a recapitulation of the entirety of the document. And you know this was done by a third-party transcriptionist. It was not done by the doctor himself. Otherwise, it would not be included as an addendum. The doctor did not even take the time to incorporate this review of records within the body of his own report. So in my opinion, this review of records does not qualify as a complexity factor. You know it was done by some third-party group for which the doctor is charging 4 hours, $1,000, or who knows what the doctor's charging for this review of records. Finally, if we go to the apportionment section of the report, the apportionment section of the report is contained within this paragraph here entitled Causation and Apportionment. It's this highlighted small paragraph at the bottom of the page. So let me read this to you. It states, causation and apportionment, work related, period. He does not seem to have any major pathology to suggest apportionment from the get-go. Issues come up as to whether subsequent employment made situation worse. I perceive that there might be 5% apportionment to subsequent employment with such and such company, which added his problem and his elbow disability in 2009. Does that discussion of apportionment qualify as a complexity factor? It does not, does it? It does not. First of all, there is no discussion of apportionment. He does not describe the percentage of permanent impairment due to the industrial injury and the percentage of impairment due to other factors. This is not a discussion of apportionment in general, and it's certainly not an apportionment complexity factor. And so this is a report that probably was an ML 102 to ML 103 report, for which the doctor artificially escalated the report to an ML 104, and then from there artificially escalated the report from $2,000 to $4,400. And this is the type of report that ended up on the division of, that's likely to end up on the desk of the Division of Workers' Compensation. And this is what has the Division of Workers' Compensation inflamed. Let me share with you another report. This is a report that involves a 12-page report. The 12 pages of discussion by the doctor. The remaining 40 pages involves the review of records. Again, the review of records in this case includes an entire recapitulation of every document that the doctor received. It does not describe the doctor's interpretation of the review of records and the data within the review of records that's salient or relevant to the doctor and upon which the doctor's opinions and conclusions later on in the report can be based. So in my opinion, this review of records does not qualify as a complexity factor. This is, again, a reevaluation report. This is a psychologic reevaluation. For this report, the doctor billed roughly $12,000. $12,000. The report itself is 12 pages with 40 pages of review of records. And again, the doctor apparently uses a template from his clinical practice that's not customized to the California workers' compensation system. There is no documentation of face-to-face time. The review of records does not qualify as a complexity factor. And in summarizing his time involved with all activities, the doctor lumps together time involved with review of records and time involved with discussion, including addressing causation, apportionment, further treatment, and work status, all together for a total of 29 hours. So in describing the time, it says face-to-face time with patient 4 hours. That qualifies as a complexity factor, but the doctor does not document the start time and does not document the end time. The doctor does not include a signed sign-in sheet where the examinee initials the start time and initials the end time. Next line item says reviewing the submitted records, reviewing the testing, reviewing my prior report, and discussion, including addressing issues of causation, apportionment, further treatment, and work status, 29 hours. So herein the doctor somehow combines activities into seemingly the review of records complexity factor for 29 hours. And then an additional 5 hours for preparation and report editing for a total of 38 hours as an AME, and this report comes in at almost $12,000. Well, let's take a look at the causation and apportionment sections of this report. As I said, this is a 12-page report with the review of records comprising 40 pages. So let's go to the causation and apportionment sections of the report. Here's the causation discussion. Causation. These issues will be addressed when Mr. Jones's psychological condition has stabilized at a maximal medical improvement for rating purposes. Does that qualify causation as a complexity factor? That one sentence which says, I'll discuss causation later. In your opinion, would you reimburse causation as a complexity factor with that as the description? How about apportionment? Here's the apportionment section. It's this little tiny paragraph right here. Apportionment. The apportionment section includes apparently canned, templated, boilerplate language with no relevance at all to Mr. Jones. It says, I have seen no evidence of any active pre-existing psychologic disorder or disability to which apportionment could reasonably be made. Mr. Jones was able to function well in his employment. There would seem to be no grounds for apportionment to any non-industrial factors once the patient becomes stationary for rating purposes. So the doctor here is invoking apportionment as a complexity factor prior to the examinee being declared to be permanent and stationary. He then continues, he says, this conclusion is, of course, tentative and subject to change when the patient's condition has stabilized. At that time, the issue of apportionment will again be considered in detail. I don't know what he means by again considered in detail, unless he considers this to be in detail. And all additional information will be examined before any final recommendations are made, and this is canned, boilerplated, templated language that does not discuss apportionment in an examinee who's not yet permanent and stationary. So the causation complexity factor does not apply. The apportionment complexity factor does not apply. In my opinion, the review of records complexity factor does not apply. So this is a report that qualifies for either an ML 102 or an ML 103, but which was artificially elevated and escalated to an ML 104, and then was billed for a total of almost $12,000. And this is the type of concern that the Division of Workers' Compensation has, that qualified medical evaluators are misusing the complexity factors. Where do we go from here? How will we take this new opportunity that the Division of Workers' Compensation has given us? Will we continue to exploit the complexity factors, or will we toe the line and follow the complexity factors according to the exact letter of the law? Finally, as just one more example, I have here another report wherein not only does the doctor in this case misuse the complexity factors, but also misuses the modifiers. Now, this is a 2017 report, and the author of this report, declares himself to be the agreed panel qualified medical evaluator. The agreed panel qualified medical evaluator, the APQME. Now, the APQME has ceased to exist since 2013. This is a 2017 report. Now, I'm sure this doctor is aware that the APQME was abolished in 2013, but he continues to cite language from pre-2013 and continues to use the APQME sort of as an error of omission rather than an error of commission. And this error of omission is what allows him to add a 25% bump to his overall fee. Okay, so keep that in mind. By the way, there seems to be some misunderstanding amongst the profession that when you have a represented injured worker and a panel is issued and the parties, each of the parties strike a name from the panel, the last man standing is not an agreed panel QME. The agreed panel QME was abolished in 2013, first of all. Second of all, there's no way you can make a case that the last man standing in any way represents any kind of an agreement. You're the last man standing after others have been struck. There is no agreement. They simply struck a name. So to invoke the agreed panel qualified medical evaluator is not only erroneous, invoking it when you're the last man standing is not only erroneous, it's not even consistent with the current language of Labor Code 4062, which was changed in 2013 to abolish the agreed panel qualified medical evaluator. But here, this doctor misuses the complexity factor, or the modifier, to give himself a 25% pay raise. And that's not the worst of it. In addition to that, the doctor does not record his face-to-face start and stop time. He claims review of records as a complexity factor, wherein the review of records is done by a third-party transcriptionist and simply involves a recapitulation of the entirety of the review of records, which, as we said, does not qualify as a complexity factor. And then in addition, I want to talk to you about medical research. The doctor employs 1.5 hours of medical research. Now, in my entire career as a qualified medical evaluator, I've used medical research as a complexity factor maybe 50 times out of over 1,500 evaluations. Maybe 50, maybe not even 50. It's rare. Well, I've never, ever required 1.5 hours of medical research. So when I read that this evaluation required 1.5 hours of medical research, I was quite curious as to what that medical research consisted of. And I'll share that with you in just a second. So in any event, he also invokes causation as a complexity factor, medical research. Total, the entire evaluation comes in at $4,500, which when multiplied by a 25% pay bump for the agreed panel qualified medical evaluator, plus an additional 10% pay bump for the interpreter, brought the evaluation to a total of $6,075. And by review of this evaluation qualified for no more than an ML 103 at $937.50. So this is more than a $5,000 overbilling on this report due to misuse of complexity factors and due to misuse of modifiers. So let's go to the medical research section of this report. And by reviewing this entire report, I found that there's no section in the report relating to any medical research. So it describes 1.5 hours of medical research. That's substantial. You would think that within the report there would be a very impressive section of the report talking about the results of this 1.5 hours of required medical research. But nowhere within the report is there any section heading entitled medical research. Well, I had an opportunity to discuss this with the doctor, and I asked him, what was your medical research? Your report describes 1.5 hours of medical research. Where is your medical research? The complexity factor for medical research tells us medical research. When using an evaluator who specifies medical research, must also provide a list of citations to the sources reviewed and excerpt or include copies or medical evidence relied upon. So I looked through the report to see the citations, to see the listing of medical research. I was curious, and it's contained nowhere within the report. So I asked the doctor, what was the medical research? And he told me that the medical research involved him having the examinee fill out a specific symptom questionnaire. In other words, he told me that he found this examinee to be not totally credible, not totally sincere. So he had the examinee fill out a specific questionnaire, which I believe was called the Waddell's Waddell's Fear or Pain Avoidance Questionnaire. And he interpreted that questionnaire, and in his opinion, that qualified for 1.5 hours of medical research. So in my opinion, not only does that not qualify for 1.5 hours, 1.5 times $250 is $375. That's not so much the greatest aspect of the sin involved with that invoking medical research. The $375 is not the greatest sin. It's the fact that the medical research escalates the report to the ML 104 level. It artificially escalates the report to the ML 104 level and substantially allows for higher level of billing than simply the ML 103. So I could write off the 375. That's the lesser of the two evils. The greater of the two evils is that he used the medical research, the non-existent medical research, to artificially escalate the value of the complexity of the report to ML 104, which allowed him to bill $6,075 for a report that qualified for no more than an ML 103 at $937.50. So doctors, I hope you get the point on this. I've spoken on this before, and I've done continuing education courses specifically related to fraud in the workers' compensation system, and fraud is rampant in the workers' compensation system. Well, according to a recent study by the Workers' Compensation Institute Review Board in 2017, Qualified medical evaluations, QME reports that is, are being reimbursed at approximately 1/3 of $1 billion annually. Of that 1/3 of $1 billion annually, the Division of Workers' Compensation is concerned with how much of that is overbilled, how much of that is artificially escalated, artificially elevated. And the Division of Workers' Compensation, in reviewing random reports from QMEs seeking reappointment, found that, oh my God, qualified medical evaluators are not complying with the language of the complexity factors as they're written, and that's what, in my opinion, caused the Division of Workers' Compensation to clamp down and provide a new interpretation of the complexity factors. Well, now, after time and great fight, a settlement agreement has been reached, and I'm asking you to join me in using this as an opportunity to improve, and perfect your reports so that they're beyond reproach, so that they're above all scrutiny, so that your reports are perfect and comply with the exact letter of labor codes, codes of regulation, and the complexity factors. If you can do that, you can confidently send out each and every report at your billing level that you sincerely qualify for, with not one single minute exaggerated and not one single minute underestimated, but billing exactly for what you do in exact compliance with the complexity factors. Now, in our next discussion, we're going to take this a bit further, and we're going to talk about how this new opportunity, this lifting of the oppressive interpretation, how this is going to affect the face-to-face evaluation. And I'm going to share with you some ideas as to how to satisfy the Division of Workers' Compensation, how to make them happy that you are one of the compliant doctors who sincerely wants to be practicing as a qualified medical evaluator for years and years to come. So doctors, I hope this helps you. It's my intention and my intent that you retain your QME credential for many years, and that you fly underneath the radar of the Division of Workers' Compensation's disciplinary actions and proceedings. So for today, this is Dr. Perry Carpenter. I want to thank you for taking the time to join me on this week's video. Look forward to being with you again very soon as we continue our ongoing discussion entitled The New Era Face-to-Face Evaluation. For now, I'm wishing you best of success in your career as a qualified medical evaluator.